Peace, everyone. Welcome to the Moorish Midwest Educational Network. This is the date's March 19th, 2025, 7 p.m., 7:10 Eastern Standard Time. This is the second session of the Moorish Midwest Educational Network educational session. We have we have here. So this is sessions are every first and third Wednesdays of the month from 7 p.m. to 9 p.m. Eastern Standard Time, live on the Zoom platform. This is a recurrent Zoom link. Please share the link, post the link on your social media, let people know. And then also the recorded classes can be shared, let people know so we can increase the platform. All right, so we go to the next slide. You want to read this summary, Israel?
Yeah, so the summary. This study lesson will help guide the Moors/Black Moors/Blackamoors/Blacks in analyzing and addressing the continued European discovery, conquest, subjugation, and colonization of our lands by the United States, and how Article 4, Section 3 and the 14th Amendment is being used to maintain our subjugation and international law application known as acquisition of nationality through subjugation and cession.
So this is the day's presentation. We had the presentation on Moorish Monday, this past Monday. First session, follow up and overview. You want to read that?
All right. The United States Constitution as the continuation of European discovery, conquest, subjugation, and colonization of Moorish lands and the subjugation of Moors. Article 4, Section 3, and the 14th Amendment are international law applications. Application of territorial sovereignty.
And as well as the acquisition of nationality and through subjugation and cession. This is a preview of our book. Israel and I are working on a book, and this is the title of our upcoming book. The projected date is the spring of 2026. It's projected release date. These questions were written by Regina Willis. She's on with us tonight. She's 2 hours outside of Chicago. She's part of the Moorish Midwest Educational Network. Questions from her kin following. I will answer all the questions from a national principle perspective, pre-existing Moorish sovereignty, recovery of lost Moorish sovereignty, post-millennium blood right tied to our land, modern race paradigm and generational mass dehumanization and mass denationalization of our people. Individual perspective versus national identity, national principle, and national political unity perspective. Since we have an audience that can give us immediate feedback, as far as verbal, and then we can verbal feedback, we can I'll actually pause and get some feedback on how I answer the questions.
Question number 1. Why does nationality matter?
All right. So we're looking at nationality and why does it matter? And looking at examples of how nationalities function throughout the world. Understanding the national principle concept of nationality. Our people are divided. We look that's conscious Moors as well as unconscious Moors. We are divided in our activities, economics, social activity, political activities, community activities, and what will nationality do? Because dealing with the principle embodied in the principle of nationality is collective self-determination, national political unity. So nationality matters is that it will restore the national political unity among our people. And so this division that exists among our people was done through social engineering. When you strip a people of who they are, that's their nationality, their history, culture, rituals, ceremonies, headdresses, celebrations, holidays, languages, uh, 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 clothing, food, dietary laws, Jewish prudence. When you strip the people of that knowledge, it falls so their center is gone. So they can be fed. And remember, this stripping was done by removing the children from because you can't strip, right? You can't strip Israel of what he knows. So the stripping is taking the children away. That's the stripping. Because you can't strip Israel what he knows. You can't strip me what I know. You can't strip Quasi of what he knows. So let's talk with the stripping is taking the children away. That's the stripping. Taking the children away from the parents, at 1 day old, 5 days old, 1 year old, 6 months old, 2 day, 3 day, 2 years old. That's the stripping. So then that way, there can be indoctrinated by foreign power. So that's the stripping. Because you definitely can't strip the adults of who of the knowledge. So it matters that it will restore national unity among our people, and that is huge. That is huge. So keep that in mind. So before I go on, any questions? All right, we can go to the next one. Next question.
What what happens? So
Yeah.
the question was why does nationality matter? So what's some negative abuses when you take away a nationality from a body of people? What do you begin to see happening to those people, and how does that play out from stripping their nationality? How does that leave room for things to come in and be able to manipulate the people? What are some of the tactics that you've seen that's being used to maintain that position after the strip?
Well, not by stripping us of a knowledge of who we are as a people. We begin to see the fighting among each other. The fighting among each other, hatred among each other, because the foreign power, the European foreign powers, facilitates that. That was facilitated as has been facilitated in Burkina Faso. The French had control of the media. So let me use Burkina Faso, Niger, and Mali. That's part of the Sahel states. The French had control of the media, their media. So the French were, when controlling the media, they would put out negative, views and indoctrinate the Bokanabe people, with negative concepts, fostering division through media. So in fostering division, it does not enable people to build the economics, to work together socially. It was and also in the French impose a certain dress, you know, among the students and the judges, Bokinabe judges. So now they don't identify with themselves culturally. They're identifying with the foreign power. So that's one of those are some of the negative effects of not working together, not building economics, not protecting one another.
I mean, we see it daily, and as far as the laws and stuff are concerned, I mean, the laws are now against us versus for us.
Well, you're going to be the law against us is called subjugation.
Exactly.
You're going
So
to it's
without
subjugation.
the so without the nationality, all of these things just continue.
Yeah, the subjugation. All of these things is known as subjugation. The subjugation will continue. Mm-hmm. I want to place the international law terminology or what you're saying, Regina. The things is known as all of the things is known as subjugation. Just the international law application. All right. So we want to invoke international law. We want to invoke international law by using the word subjugation. It's not just a word. It's not just a word. All right. It's a principle of oppressing a people. There's an application. There's different applications. You have, subjugation, you have occupation, and there's different elements. So it's subjugation because that invokes international law. And then when you're using subjugation, it's the subjugation of a nation of people, not individual. So when you say subjugation, it's not Regina, it's not quasi. It doesn't apply to individuals. It applies to a nation of people. When you use subjugation, there's and because of the application, a nation of people. It's a nation of people is being that we are part of a nation, and that we as a nation of people is being subdued by foreign power when we use subjugation. I have to explain why why it's important for us to use subjugation. Like you was talking about the native people of Hawaii, you will use subjugation. United States is subjugating, not abusing. We won't use the word abuse. We don't use the word abuse. Why not abuse? All right, what's the difference? United States is abusing the native people of Hawaii versus United States is subjugating the native people of Hawaii. What's the difference? What's the difference? Subjugation is the international law application. Abuse is not. So subjugation brings up the fact that a nation is being subdued by another foreign nation, foreign power. When you say abuse, we're not going to say violate, we're going to say subjugation. So the words do matter because it invokes certain particular applications in international law. Right. Next. And this is what I was saying 2 weeks ago, that just saying international law is not going to get it done. We have to be specific as opposed to say we have to use specific principles and identify the particular principle that's being applied, particular international law application that's being applied.
Substantive language.
The substantive language. So there's elements. There are elements. So when you're looking at the different applications, there are elements for each of the different application, you know, occupation, military occupation, subjugation, conquest, territorial sovereignty, acquisition of loss of sovereignty. So there's elements that will identify the particular application or principle in international law.
Before we move on, I just wanted to
Mm-hmm.
let you guys know that I put an article in the chat. It's on nationality. It's called Nationality Including Statelessness. It was a report by Special Rapporteur Manley Hudson in the United Nations. And it does, this was one that I had seen a while ago, which kind of helped me gain a better understanding of the concept of nationality. They talk in here, and it kind of answers directly to this question as well. I just want to read a small little portion. That
Absolutely.
nationality,
Yes.
nationality is usually defined in terms of municipal law. The following definition is more general. Quote, nationality is the status of a natural person who is attached to a state by the tie of allegiance. Distinctions made by municipal law between various classes of nationals are, as a rule, immaterial from the point of view of international law. They become, however, relevant if a state creates a class of nationals in regard to whom it does not assume the same rights and obligations inherent in the above-mentioned concept of nationality for the purpose of international law. And then it says the treatment, and they use one example, but it would also apply here with subjugation of the Moors. But so the treatment of German Jews by Nazi Germany is a case in point. The Reich Citizenship Law of 15 September 1935 provided that Jews, though German subjects or nationals, could not be Reich citizens. Jews had no political rights. In the course of its policy of persecution, Jews were, by legislative and administrative measures, gradually deprived of all rights usually attributed to nationals under municipal law and of the protection by the law. Their status was inferior to that of aliens. By the 11th Ordinance under the Reich Citizenship Law of 25 November 1941, German Jews who had their ordinary residence abroad were deprived of German nationality, and then Jews were forced to emigrate from Germany. Later, the government resorted to mass deportation and ultimately the extermination of the Jews. German Jews abroad were not given diplomatic protection, and thus a usual consequence of nationality was denied them. And the article as well talks about some of the concepts that we've been discussing about like acquisition of nationality, how when territory is acquired, how the nationality would be changed from the seeding state to the new state. And so it has some of that as well, but I think that kind of as well spoke directly to that question. So I just wanted to add it.
Yeah, we'll definitely get into that second part, the change of sovereignty and its effects upon the nationality of the inhabitants. That's what you're talking about. Absolutely. And you see with nationality, it's a class, it's a body of people, a class of people. It's not when you an individual belonging to a nation. So it ties an individual to a nation. It's not where it's just an individual identity. It's a national identity of a people. It's not exclusive. Nationality is not exclusive to an individual. It ties an individual to a nation and affords and where through allegiance, and therefore affords that individual protection, but it's not exclusive to an individual. So there's no individual quality because it's not exclusive, to an individual. That the name, the national name, the nationality is Chinese. It's not exclusive to an individual. There's no such thing as self-identification. I know that's used. I know the United States uses that. That's a fiction. Say self-identification. What is that? Like, what is self-identification? You have clan names, right? What they call last names. You have a body of what they call last names or clan names. It's not self-identification. They're clan names. That individual that ties the individual to a clan by the name. Reagan, that's an Irish clan name that's been anglicized. Kennedy, an Irish clan name that's been anglicized. That's not self-identification. Reagan is not self-identification. That's an Irish clan. Kennedy, Irish clan. So now we're talking about name because they're clans. They're clans. You have clan names. You have patronyms, father names. You have place names. So those who lived in a particular area or near a Brookington, the name that was forced, the English family name that was forced to my family, Brockington. Brook is a stream of water. Ton means land. So those who lived near a stream of water or brookings, Brockington. So now we get into the history. So it's just not merely, so that's what I'm saying, this self-identification doesn't exist. Because it's not exclusive. So even what they call family names are not exclusive to an individual. It's just people don't know the history, that's all. Because you're talking, it ties to genealogy, heraldry. I continue with next one.
Question number 2. What does declaring my nationality do for me?
All right. So we have me again, what I did on Monday night. We have the personal pronoun, objective case, singular, me. What does declaring my, and we have my personal pronoun, possessive case, singular, do for me? Let's look at what does nationality, what would nationality, what would declaring, what would nationality do for our people? Like, why is it not people? Why is it me? So we have this individual, once again, that they're thinking individually and not national from a perspective of our people. What does it do for me? Well, what does it do for our people? And I've seen this for 33 years. This question. I've heard this question for 33 years. I've never, all right, hear me out, my brothers. I've been in a lot of classes. I've been in a lot of circles with conscious Moors, unconscious Moors who are at conscious Moors classes. I've heard this. I've heard this question over 500 times. I've heard this question over 500 times at lectures, classes in New York, Camden, Philadelphia, over 500 times. All right. What haven't I heard? I haven't heard this question. What would nationality do for our people? I don't hear that. Why not? Why haven't I heard in all these classes, lectures that I've been in 33 years? Why haven't I heard from conscious Moors, those who are becoming conscious in that class? Why haven't I heard what will nationality do for our people? Why don't I hear that? I'm serious. Why not? Why do he keep hearing this? Why not our people? Why keep hearing the same? This 33 years, y'all. What's going on? What's going on that I keep hearing this? And it's still going on. We talking about ongoing now, 33 years and counting. Why don't we hear our people? Why not? Why this question? Why not our people? Can I get some feedback, please?
That's actually one of the effects.
You're muted. You're muted.
My apologies. My apologies. That's actually one of the effects that went with the first comment on about what happens under subjugation. I did some research on what happens when you take a child from his mother, and the same alchemical effect that is suffered by the child is suffered by us, by a people. Our lack of ability to bond with each other, our lack of ability to trust, a schizophrenia type mind where it runs wild. I'm gonna try to find an article and see if I can't put it in the chat, but it was sent out to all child protective services because that's what they do. You said it starts with the children. Most of the people in child protective services are us. But those effects on that child, pulling it from his mother, pulling it from his natural bonding routine in nature, it lessens us as a people. So as we get older, it becomes an individual pursuit of everything that we do. Like we can't do it as a whole. We don't look to us as a working part, as somebody being the arm, somebody being the left arm, the right arm, as a whole, like a Voltron, if I might use that, if that makes sense. I yield.
That's a good point. Thank you for that. That's why I'm asking for feedback. It's good point. Anyone else? This is very important because this is continue to go on. We immediately go with that. We immediately go with the end of why though? We know why. We got to break that though. Right? We can't continue with that. We can't continue with this question like that. Like, where would it get us? I mean, I've seen it with conscious Moors, though. I've seen this selfishness. I've seen this selfishness. Maybe help me out. If I'm using the wrong word, help me out. I'm not right about everything. I mean, I can be challenged. Challenge me. I mean, I'm saying selfishness. It may not be selfishness. I'm using that. I may be wrong. But I've seen this selfishness among conscious Moors. I've been involved with unconscious Moors, and I'm probably one of the few that you know. Probably one of the few that you know. I'm probably one of the few conscious Moors that you know who's been involved with conscious Moors activities, that's classes, different activities, as well as unconscious Moors activity, that's classes and different activities for 33 years. I have both experiences. I have both experiences with large bodies of conscious Moors, have both an experience with large bodies of unconscious Moors. I taught nationality to 5,000 unconscious Moors in the Kansas City Public School. I've talked to over, I've spoken, had discussions, educational discussions, over 500 co-workers, both Europeans and unconscious Moors. I ran my big mouth. And you already know my experience with conscious Moors. So I'm one of the few that you know. Whereas conscious Moors, only their experience is with conscious Moors. Now, Quasi, his experiences is both. Quasi has large experiences, you know, with unconscious Moors as well. But very few conscious Moors have I'll tell you what, very few Moors, conscious and unconscious, have my experience. Very few Moors, conscious and because of course unconscious Moors don't have experience with conscious Moors like that. So that's why I say very few Moors have my experience. Because conscious Moors, they just seek to stay with conscious Moors. And Regina and I talked about this a couple of days ago. They just stay with conscious Moors that click. I've seen it. And we got to break that. Any feedback? I just want to spend some time on this section. This is very important. These questions are very important. I want to thank Regina again. All right, go to the next question.
Question number 3. Looking at all the negative media about Moors, why would I want to be a Moor?
All right, so this question, of course, the person lacks knowledge of that Moor. That is not a choice. It's not a be. It's not a you want to be. All right. Looking at all the negative media about cats. Now I'm a cat. I'm a cat. Looking at all the negative media about cats. Why would I want to be a cat? What's the difference? I mean, conceptualize. There's no difference. It's conceptualize. They're Moors. It's not something you want. It's not something that you can want to be. You can't want to. Our people can't want to be a Moor. They are Moors. A cat can't want to be a cat. A cat's a cat. It's not a want to be. Can't want to be who you. This is genetics, ancestry, lineage, consanguinity, ancestry, descent, parentage, pedigree. It's not a want to. It's just, restoring the knowledge of it. It's not a want to. You can't, it's not a becoming. You can't become a Moor. You can't want to be a Moor. We already are. So this is a lack of knowledge. So you see how I'm addressing? All right. If someone answers this way, looking at all the negative media about Moors, why would I want to be a Moor? And someone asks, well, it will give you protections. See, then now what you have done, because you didn't clean it up. See happened? See, then so they didn't clean it up. They said, oh yeah, see, being a Moor, it affords you treaty protection. But you didn't clean it up though, so you're wrong. I mean, you're wrong in that you didn't clean this up. So what happens is you didn't actually, this is a false, this is a colorable question. So you didn't educate the one who asked the question that this is the callable question. So now the person, because you said, yeah, what it would do, it affords you protection, you know, and international recognition. So now the person, right, walks away thinking that it's something that it's becoming. They got to become. It's, you know, why would you didn't clean that up? Please let me out. We got to analyze. We have to analyze the question and point out that the question is colorable. We don't just jump in it, because then you just what? That person now walks away thinking that they gotta become more. See? Ain't no becoming no more. And ain't no, a cat can't become a cat. A cat's a cat. A cat is a cat. This is important. That's why you see I'm taking my time with this and analyzing. This is critical thinking hour. Critical thinking and analysis hour. Next one.
Question number 4. How does nationality affect my day-to-day activities?
Yeah, and let me go back to finish up number 3. And then they'll say, you know what I mean? Don't accept that, please, my brothers and sisters. Don't accept, you know what I mean. Don't accept, you know what I mean. Clean it up. Don't try to rush and you ain't rushing me and all that. It's not, you know what I mean. Because their concepts are wrong. You don't want them to view. You don't want to view nationality as they don't want them to view the Moorish nationality as a choice of becoming. It's our ancestry, pedigree. Those who've been in the grave for 200 years, 50 years, 100 years, 200 years, 300 years, 400 years, 500, 700, 800, 900, 1,000, 1,200, 1,300 years. We're tied to them. It's called ancestry, descent, genealogy of a people. So we talk about a national ancestry, national genealogy, national pedigree of a people that's been in the grave for 100, 500, 700, 800, 1,000. You tired of them too, not just those who are living. So it's about having to give by setting the proper concepts. We cannot have that person walk away thinking they gotta become a Moor. That's a false concept. And they walk away with that, you just answering, they ain't no further along than they were when they asked the question. Because you didn't advance them because you didn't clean the question up. All right, what's the 4 again? V4 again now, Israel. I just wanted to reiterate that point.
Question number 4. How does nationality affect my day-to-day activities?
Here we go again. My personal pronoun, possessive case. How does nationality affect our people's day-to-day activity? I have to do this because we gotta rid this my. We have to rid this individual connection. There's no what they say. What do you read, Amanda? That it connects an individual like
to a state. Nationality is hold on one second.
So it's not exclusive to that individual.
No, it's not exclusive to the individual. It's the It's not pulling up at the second, but
Mhm.
vaguely. Nationality is the status of a person, a natural person by their tie of allegiance to the
By the
state.
tie of allegiance to a nation state.
Yes,
So that's what, to a body of people that hold that same nationality.
correct.
So they what? That ties them to a body of people that's identified. So it identifies a whole body of people, not an individual. It doesn't, nationality doesn't identify an individual exclusively. Chinese. Hey, well, did you see one Chinese? But that Chinese is connected to what? A body of people. That's like the state, treaty protection. It's not exclusive to an individual. They got it. It's exclusive to an individual, to these 5 or 6 these conscious. No, absolutely not. So this got to, we just got to, we have to get stronger with this concept of nationality. It's not strong. It's not. It's not strong among conscious Moors. It's not. Nationality is not strong. You know what? It's weak. Nationality is weak as far as the understanding of nationality is weak among conscious Moors. Other than it doesn't go beyond, I'm not Negro, color, black. That's it. It stops there. I'm not Negro, color, black. I'm a Moor. It doesn't go beyond that. Like it being connected to sovereignty, a national identity of a people. It's not there because it's all individual activity. Like there's no work to facilitate national unity, national principle concept is not collective self-determination. That's not there among conscious Moors. Like they don't tie that to nationality. It's my individual paperwork. I'm nationalized. I got my paperwork. This is it's weak. It's weak, man. It's weak. I continue. Next one.
Question number 5. How do officials recognize Moors and uphold their rights?
They don't. All right. Let me ask. Man, they gonna hate me, but I don't care. You know I don't
It's the
care.
truth, man.
You know I don't care. All right. When state courts or even district court, United States District Court, they'll respond by writing quote unquote Moors. That's not a recognition. Like you didn't put quote unquote Moors. Like what is quote unquote Moor? What is that? All right. What's a quote unquote Chinese? I don't know what that. I mean, I don't know, but I don't know what that means. They dare not do that. They dare not put quote unquote Chinese because that's not a recognition. So-called, self-identified, quote unquote. That means there's not a recognition. And I'm gonna continue. The recognition they will call a Moorish consul. They don't have power to hear the case. I'm explaining why I'm saying what I'm saying. They don't have power. They don't have power to hear the case. Like, you're a Moor. They recognize you as a Moor. They can't hear the case. You're not a citizen. Or there's a treaty that has extraterritoriality clauses. Like Howenstein versus Lynham. Why did they hear that case? Why did the Supreme Court hear the Howenstein case? Why did they hear the case?
The treaty between the United States and Switzerland provided that Swiss citizens who had their property here would have disputes heard by United States courts.
There's no extraterritoriality clause. Exactly. There's no extraterritoriality clause. So Article 3, Section 2 of the Article 3, Section 2, with the various 7-8 clauses of the United States Constitution, allows the Supreme Court to hear treaty cases, but not treaty cases with where the treaty has extraterritoriality clauses. That what? That power by treaty belongs to a consul, a French consul, or whatever, German consul or Persian consul. So it doesn't belong to a United States court or United States judge or district judge or prosecutor. So it's only a consul, only a Moorish consul, only a Dutch consul, only a French consul. There's over 600 pages in the counter memorial, United States counter memorial in the case between the France and the United States, 1952 case, International Court of Justice. I have in Moors and Masonry Part 2, and I also put it in one of the lessons I've done in the advanced study group. I took 10 pages out of that 600 pages. I have the treaty cases, treaty clauses dating back to the 1600s, 1700 treaties. They have the extraterritoriality clauses. Only the Dutch consul, only the French consul, only the Spanish consul. See? That's the recognition of their calling the consul. The recognition is that they recognize they don't have the power to hear the case. That's the recognition. They had the power to hear Sauenstein's case, but because it allowed an individual, because you have what's called self-executing and non-self-executing. Does the treaty have what's called a personal right of action? A personal right of action whereby an individual can bring the case. So if it doesn't have a personal right of action, meaning that an individual can't bring a case, it would have to be a consul. So you have to look at the substantive language in the treaty. So that's the recognition. And they wouldn't be putting so-called Moor and quote-unquote Moor. They're hearing your case, but are they recognize you as a Moor? No, they're not. Stop it. Stop. Stop. They're not. It's like they would hear a case classified as Negro, color, black. They hear a case with a conscious Moor, classified the same, but are they recognizing us as Moors? They're not. what has to happen? Why do you? I'm not gay. I'll explain why. I didn't just say it. I'm explaining why they're not recognizing as Moors. Because they don't have the power to hear the case. They can't. The fact that they're moving forward with the case in the state courts and the district court, they're not recognizing us as Moors. They're treating you as if you're the 14th Amendment. You're being what? Conscious Moors. We're talking about conscious Moors. Conscious Moors. 14th Amendment. Conscious Moors don't know enough. All right, next one.
Question number 6. What changes do I need to make to prepare for Moorish life? What will be different?
All right, so there's the I again. There's the I, personal pronoun. Nominative case, singular. What changes do our people need to make to prepare for Moorish life? What will be different? Because once again, they're not seeing it from as a national identity. They're not thinking our people, though. This matters, my brothers and sisters. Because we keep thinking individual. And I've seen that with conscious Moors, this individualistic thinking. Right, we move on because that's the whole concept. That it's the same concept.
So
And I'm not
nationality,
ducking any questions. It's important that we identify the individual, that the questions do not take into thought the collective self-identity, self-determination, the national political unity principle that's embodied in nationality. Does not take that into thought. That's really what I'm hammering on. Go ahead, Israel.
nationality, the national identity of a people, identifying their political allegiance and political protection.
Of a people, not an
Constitution,
individual.
right, right. Constitution, the written expression of the political unity of a people.
Oh, this got to be hammered.
Yeah.
This is what I'm hammering. It got to be hammered, my brothers and sisters. It hasn't been. You. This is raising a people up. This gotta be instilled. Otherwise, you're not raising them up. Even if you say that they're Moors. But if you are facilitating this individual concept and tying individual concept to nationality, you're not facilitating national political unity. So it's like it's never ending. You'll get burnt out. We got to facilitate in our teachings the way I'm doing it, my brothers and sisters. I'm 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 guiding on how we have to by instructions, by it gotta be part of us, by our activity. You to speak, Quasi. Quasi, can you take the floor? Where's Quasi?
He dropped
He
out.
left the building.
Oh my goodness. Oh man. It's because all right. Shucks. Now he's great. Okay, can go to the next one. He would have been perfect to bring his experience in.
The phrase "in the United States," used in a geographic sense, came about through the various land boundary cession treaties whereby Great Britain, Spain, France, and United States of Mexico transferred their territorial sovereignty over our lands to the United States through cession treaties. The cession treaties are land titles in international law. This is a continuation of European discovery, conquest, subjugation, colonization of our lands, and the continued subjugation of our people. Article 4, Section 3 of the United States Constitution is how our land is managed under the authority of the United States Congress.
Now, the core principle, territorial sovereignty, is very important. This was the first class. We have we're better prepared with this class with these PowerPoints, and this core principle you're going to see. This is going to raise y'all up. It's going to raise y'all up. To know what's going on with our land, to know that there is the continuation of European discovery, conquest, subjugation, and colonization. You got to come to know the international core principle of territorial sovereignty and how that is embodied in the United States Constitution through Article 4, Section 3, Article 1, Clause 8, Section 8, Clause 17. This is very important. This is a very important core concept to really to come to understand the continuation. That it was transferred to the United States. And you're going to see that we have the maps. We have the maps. We have a lot of visuals today. So I want you to reread this, Israel, this phrase.
The phrase "in the United..."
This slide, I apologize.
So the phrase "in the United States," used in a geographic sense, came about through the various land boundary cession treaties whereby Great Britain, Spain, France, and the United States of Mexico transferred their territorial sovereignty over our lands to the United States through cession treaties. The cession treaties are land titles in international law. This is a continuation of European discovery, conquest, subjugation, colonization of our lands, and the continued subjugation of our people. Article 4, Section 3 of the United States Constitution is how our land is managed under the authority of the United States Congress.
All right, we're going to see it. We're going to show how this is played out. This is very important here. How this phrase came about in the United States. All right, we're going to come back to this as we can go forward with this presentation. So we explain how this is, so we're going to show through the maps. We're going to show, you're going to see the maps, and we're going to tie the various treaties that brought about the changes of the maps and how the territorial sovereignty, which is a core principle of international law, is transferred. I continue.
French Louisiana, 1682 to 1762 map.
All right, so you don't see United States. Why don't you see United States here? The phrase "in the United States," how'd that come about? All right. The maps today, 2025 map, you see United States here. Like this whole land mass will be you'll see the United States. But why don't you see it here? Like, why don't I see United States here? How did the phrase "in the United States" come about? This is 18 French Louisiana, 1682 to 1762. Why is it French Louisiana? What does this? Because French what? Has territorial sovereignty over this body of land, and that these boundaries outline what? France's territorial jurisdiction. The authority, the power by which France is exercising, all right, over this body of land. So has to see the boundaries, because there's Spain over here. The green the green is not, have Great Britain, because this is the boundaries. So a survey was done under Louis XIV, and named after him, King Louis XIV. So the survey map becomes the title. The treaty is by which the title is transferred, which there's territorial sovereignty. Territorial sovereignty is transferred by treaty. The territorial jurisdiction means that the power by which the state is exercising, the boundary in which the state is exercising its power. There you go. See over here, Spain. You have Great Britain. But I don't see United States. Why doesn't it read United States? I continue.
North American, Spanish, French, and British territories circa 1700. European settlements in the New World.
So we just want to show you different maps, different orientations here. So New France. Why New France? Because France and New France means that that's an extension of France's territorial sovereignty, extension of Spain's territorial sovereignty. The British colonies. All right, next one.
1762, Spanish Louisiana, Española.
Hold on, how did it come to Spain? Hold on, I'm kind of lost here. Look, it said France. How did it? Hold on.
France.
To what? Spanish Louisiana. How did it move from French Louisiana to Spanish Louisiana? What happened? What happened that it now reads Spanish Louisiana? What is that called? What is that called where there's a change in name?
Session
It's
treaty.
called the transfer of territorial sovereignty. France transfers the territorial sovereignty to Spain through a treaty called the Treaty of Fontainebleau. That's how that happens. Territorial sovereignty is a core principle. The territorial jurisdiction is based in, the foundation is territorial sovereignty. The foundation of territorial jurisdiction is territorial sovereignty. We're going to bring that back up. We're going to see this. We're going to see how that was the title of our book, the United States Constitution as the continuation of European discovery, conquest, subjugation, and colonization of the Moorish lands and the subjugation of the Moors. We're showing you, how the continuation. It wasn't France. France did not what? Return the land to the native Moors. Says what? Spain. France didn't return the land to the native Moors. So it's not a continuation. Spain is a European occupying, conquesting sovereign of our land. They didn't return it to the native people, and it's done through what? Through treaty. So the Treaty of Fontainebleau becomes the title. So the claim is what now made through the treaty. And then they have maps, world maps that reflect what? The state that is exercising the territorial sovereignty over a body of land, or now that the territorial jurisdiction belongs to Spain. So now Spain is exercising territorial jurisdiction, but the foundation of territorial jurisdiction is territorial sovereignty. Next. This different
Spanish Louisiana.
Spanish Louisiana. You can see New Spain, Hudson Bay Company. So we have the Hudson Bay Company. And what years? So this is between 1762 and 1801. All right, next one. Claims before the French and Indian War. French claims. Claims before the French and Indian War. The French and Indian War was from 1754 to 1762. So we have Spanish claims, unclaimed, Hudson Bay Company, British, French claims, and the British colonies. So this is before 1754. Next. Showing different maps, different orientations. New France, New Spain, English colonies. New Spain, with Florida, New Spain. And then it became East Florida and West Florida. Britain had one, either East, I can't remember, each one had East or West. It was Great Britain, then you had Spain. And then eventually Spain regained, the other part of Florida. And then ceded that to United States in 1818. The treaties to transfer the title, or the transfer of territorial sovereignty. That's a corpus is major. It's major core principle. Next.
United States after the Treaty of Paris, 1783.
All right, so United States after the Treaty of Paris. So what's the Treaty of Paris? That's the treaty between Great Britain, the definitive peace treaty between Great Britain and United States, 1783, Article 1. Article 1 of the treaty is where King George III relinquishes these body of lands. Relinquishes. King George III acknowledges United States viz, V-I-Z, which means namely, all 13 are named after viz, to be free, sovereign, and independent states. He relinquishes all claims. He relinquishes, meaning North Carolina, the colony, the land boundaries that's laid out in North Carolina Colony Charter was relinquished to North Carolina State. The land boundaries laid out in the Duke of York's Charter 1662 and 1680, and then the 1682 Charter is relinquished to New York State. The land boundaries laid out in the Virginia Colony Charter 1662 is relinquished to Virginia State. The land boundary in the South Carolina Colony Charter is relinquished to South Carolina State. And Israel and I will have this in our book. We'll have Article 13 times. I mean Article 1, Article 1 13 times. So we're gonna do state by state. We're gonna do state by state. So we're going to show you how Article 1 is played out visually. So we'll have it 13 times. And so we'll say that we'll have the what's it called? The stroll. North Carolina County Charter. All right. Then North Carolina State Constitution. For North Carolina State, assuming rights under North Carolina County Charter. We're gonna have that 13 times, and we'll circle, because it's all 13 are named in the Article 1 of the treaty. So here you go. So it's relinquished not to the not to the national body, but to the individual states. And that's the substantive language. Now you have the Article 2 is the language of that treaty is the language of the Northwest Territory, where part of Minnesota, Ohio, Illinois, Michigan, Indiana, and Wisconsin. We go to the next one. So we're looking at a continuation here. Article 1, they didn't relinquish it to return it to the native people. All right, so we have here states and territories of the United States, 1787. So you see the Northwest Territory. We have colony of Louisiana. That's Spain. Let's say it's Spain because that's 1787, Spain. Viceroyalty of New Spain, unclaimed territory. So it no longer reads what? British colonies. Why doesn't it read? The other map read British colonies, but why doesn't it read British colonies here? Because His Britannic Majesty King George III relinquishes to each of the 13 states. Next one.
Northwest Territory, 1787.
All right, there we go. The Northwest Territory, and we're going to get into we're going to do a PowerPoint on the history that led up to the drafting of Article 4, Section 3 of the United States Constitution. This is not that we'll do a separate presentation because that's an extensive history. We want to be able to walk y'all through. This is not law school. This is not taught in law school. All right. This is international law. This is not law. This is not regular law school. So you're not going to be able to talk to you'll be teaching attorneys. They can't teach you this. They don't know this. You say territorial sovereignty. They don't know that. Acquisition of territory. Law of secession. Like they don't know that the elements, the concept. They're lost. What's the foundation? What's the foundation of United States territorial sovereignty? What is the foundation of federal territorial jurisdiction? What is the foundation of territorial jurisdiction of a court? What is the foundation of it? They don't know. You're just wasting your time. You gotta teach them. You don't ask the attorneys any questions. You gotta teach them. They don't know this. This is international law. This is not regular law school. We beyond regular law school. This is international law school. This is outside of the purview, outside of the studies of regular law school. This is international law school. You're going to see how international law is at play in the United States Constitution, and how our land is being managed by Congress through that Constitution. Next.
Louisiana Purchase, 1803, from France.
Mm. So in 1804 map, you're going to see what? What you going to see here in the green? What name you going to see in the green?
United States.
There you go. Why? Why are we going to see United States in the 1804 map? Because France transfers French territorial sovereignty to the United States through the Louisiana Purchase Treaty. That's why. The United States can't make that decision on its own. The United States can't create a new map and says United States. They have to have the territorial sovereignty has to be transferred. This is a continuation. France didn't return the land to the native people. There's no back and forth. This is clear. It's that we didn't know this. That colonization ended. Like when the United States defeated Great Britain. It did not. Next. Oh, no, do you want to read the other sections? Read the other parts of the map?
Yeah, well, let's see. Ceded to Great Britain, 1818. We're at the top.
Mm-hmm.
Over here, Oregon Territory, 1846, treaty with Great Britain. Mexican Cession, 1848. There's the Spanish Cession.
That's Spain. That's Spain ceding it to Mexico.
Spanish
Spain
Cession,
ceding it to.
19. Yeah. Uh-oh. So the Gadsden Purchase, 1853, from Mexico. Texas Annexation, 1845, former Republic of Texas. Spanish Cession, 1819. West Florida, Spanish Cession, 1819. East Florida, Spanish Cession, 1819.
That's with the United States. Yeah, that's West Florida Spanish Cession. That's with the United States. East Florida Spanish Cession. That's with the United States. Spain cedes West Florida to the United States in 1819. Spain cedes East Florida to the United States in 1819. And why two separate? Because one it was Great Britain. It was Florida, Spain, but it became East Florida and West Florida. And Spain had one part of Florida. Great Britain had another part of Florida. That's why it's what? Two sessions. Because it's what now? Because you have two. Because it was, like I said, it was Spain, West Florida. It was Florida under Spain. Spain had all of Florida. Then Spain ceded part of Florida to Great Britain. So therefore it creates a separate territorial jurisdiction. So therefore that's why they have to have two separate treaties. West Florida, East Florida.
Over to the left, you have Hawaii Annexation, 1898, former Republic of Hawaii. And this is Alaska Purchase.
Remember, former republic, it was kingdom. All right, so the former republic, let me explain that. All right. That's not the Republic of Hawaii has nothing to do with the native people of Hawaii. That's not Hawaiian sovereignty. The Republic of Hawaii is not Hawaiian sovereignty. They're just using the same name. That's all. But it's not Hawaiian. The native people of Hawaii did not establish the Republic of Hawaii. Richard Dole did. Richard Dole of Dole's Pineapple, his son, Bob Dole, ran for senator. He was senator for years. He ran for president twice. That's his son. Richard Dole established. He led the establishment of the Republic of Hawaii. The Kingdom of Hawaii is Hawaii's sovereignty. The Kingdom of Hawaii was collapsed due to United States invasion in 1898 and followed by annexation. The Republic of Hawaii was established thereafter by Richard Dole. Richard Dole wanted to establish a state like China, France, England, Germany, Burkina Faso, a nation state. So you have the Kingdom of Hawaii, Republic of Hawaii, Hawaii State or State of Hawaii. They're three different entities. All right, they're using the same name. So I want to, offer that to provide that for y'all. The State of Hawaii is Republic of Hawaii was never a member state of the Union State of the United States. The State of Hawaii is State of Hawaii is a member state of the Union State of the United States. Republic of Hawaii never was. I have to offer that. I can't assume that people know that y'all know. I have to assume most people don't know this. So. All right, go to the next one.
Article 4, Section 3 of the United States Constitution lays out the procedure for the United States to maintain and manage our Moorish land. This is evidence of the continuation of European discovery, conquest, colonization, and subjugation of Moorish land. This article gives the United States Congress territorial sovereignty over Moorish land. The territorial sovereignty was transferred to the United States by the various treaties with Great Britain, France, Spain, the United States of Mexico, and Russia. Today, Congress is exercising territorial sovereignty over Moorish land.
Yes, through Article 4, Section 3. So Article 4, Section 3 of the United States Constitution embodies United States territorial sovereignty. Then as Article 1, Section 8, Clause 17 embodies United States territorial jurisdiction. And so we see here this map here, and is it big enough? Oh, yeah. So it has the years by which the territorial sovereignty was ceded to the United States. Spanish cession, Louisiana Purchase was the Spanish cession. It's over here. Then Mexican cession, by which the United States gained territorial sovereignty. So this is why you have all throughout this whole landmass that you see, United States. This is how the United States gained the geographical. This is how United States came to be used in the geographical sense. United States was transferred territorial sovereignty. It's the territorial sovereignty. So we can say all we want. We can say all we want. This is our land. This ain't the United States. This is our land. This is not United States. You say all you can cry and say all you want. That's not how you address it. That's childish. This ain't gonna. Yeah. This is not United States. That's not gonna get us anywhere. We got to know how to address it. Why is they saying this is United States? The world is saying it. The world is saying this is United States. How is it that the world has come to call this United States? What's that play? We're explaining it. This is how you do it. Yeah. That's not going to do anything. It's childish. It's childish. It's not going to. You're not going to move it forward by doing that. Let's explain from a scholarly perspective. Why is the world referring to this body of land? Maps. Hundreds of thousands of maps are made. Probably millions, my bad, millions. Millions of maps to be made. You had maps 1800, what? Map made in 1784. Map made in 1784, right? And then they had what? Because they gained territorial sovereignty. They have 1804 map. They had United States, where one says France. So the world recognizes this body of land as United States. Because the world recognizes what? The change of territorial sovereignty. That's in the hands of the United States. It's a continuation of European conquest, discovery, conquest, colonization, subjugation of our land. Next.
Article 4. What's that?
No, go ahead.
Article 4, relationships between the states. Section 3, new states and federal property. Clause 1, admissions. New states may be admitted by the Congress into this union, but no new state shall be formed or erected within the jurisdiction of any other state, nor any state be formed by the junction of two or more states, or parts of states, without the consent of the legislatures of the states concerned as well as the Congress. Go to the next.
Yeah, go to the next clause 2. Yes. So
Clause 2.
You see how this is. You see how it's being managed. He's reading it.
Mm-hmm.
He's reading how it's being managed.
Yeah. Clause 2. So this is Article 4, Section 3, Clause 2. Territory and other property. The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States, and nothing in this Constitution shall be so construed as to prejudice any claims of the United States or of any particular state.
You see how they maintaining the European discovery, conquest, colonization, subjugation of our land through the United States Constitution? Is this our Constitution? You want to enforce this? Y'all want to enforce this? Raise your hand if you want to enforce this. You talking about enforcing this? Enforce it. These concept boys don't know this. They're not making this connection like this. They're not making this connection. We see how we making the connection.
Oh.
Any questions? Before we go on, any questions? Let's open up for questions right now. Let's open up for questions. Comments, criticism. We don't know what we're talking about. What you can say, then you have to come with support, though. You can say that. That would be a claim. The claim would be we don't know what we're talking about. That's your claim. Then you have to show through documentary evidence that all that we're saying is an error. You're saying we don't know what we're talking about, then you know that doesn't. We're gonna then we might delete y'all because that in that you're antagonizing and that means nothing.
Islam.
Islam.
So what you're basically saying is, if we enforce the Constitution, then we're enforcing the continuation of subjugation of Moors.
Of our land. We discover continuation. We're enforcing the continuation of European discovery, conquest, colonization, and subjugation of our land, and the subjugation of Moors. Yes, I am saying that. I am saying it. Yes, I am.
Saying it too.
All right.
Yeah.
My question is, do you see that? All right. My question, Stern, to you, do you see that? All right. All right. Is it Abdullah said, or is it Stern, by looking at the evidence, have come to know that? Is it Abdullah said? Is it because Abdullah said? Which one is it, Stern? Is it because Abdullah said, or is
No,
because like, huh?
You know, facts.
it's
You said,
because the facts are lining up.
all right, there we go. Yeah. What else? Anybody else? Is it because Abdullah said, or is it because the facts are lining up?
Islam. The facts
Islam.
the facts are adding up.
Right on. And can y'all defend this? Can y'all defend the claim? I guess I don't care who it is, European, I don't care, Donald Trump, I don't care who they are, Donald Trump, I don't care who they are. Can you defend this? I don't care who they are. Can you defend this? I don't care who they are. I don't care international law degree, I don't care who they are. Can you defend it? Just present the evidence. That's it. You're presenting the evidence.
Yeah. Simple.
Right. Yeah. It don't matter who it is. Who gives a rats? Well, the evidence is going to change because it's Donald Trump? Like, huh? It changes because it's Donald Trump? Like,
It's in the Constitution. Yeah.
the facts change because it's Donald Trump? The facts change because somebody has an international law degree and you don't? Like, how does that work? The facts don't change because it's somebody else. The treaties are the treaty is the evidence, the documentary evidence by which United States acquired the territorial sovereignty. And you coming to learn international law, principles, and you'll be able to see by understanding the international law principles and the elements, you begin to see it being at work. You begin to understand it because you're understanding the international law principles and the elements of each principle. And we go to the next one. We're gonna be reading territorial sovereignty. That'll be coming up.
This is
And that's why you have the what's the name, the source at the bottom. Right there.
yeah, commentaries on the Constitution of the United States, 3rd volume, Boston, 1833, by Joseph Story. Volume 4, Article 4, Section 3, Clause 2, Document 8, Founders Constitution. Subsection 1322, the power of Congress over the public territory is clearly exclusive and universal, and their legislation is subject to no control, but is absolute and unlimited, unless so far as it is affected by stipulations in the sessions or by the ordinance of 1787. under which any part of it has been settled. But the
And
power
stop
of
there. Stop that there. It says what? Unless what? Stipulated, unless affected
less
by the stipulation in the sessions or by the
sessions.
ordinance of.
Mhm.
See, I mean
Yeah,
the set in the treaty, unless it's the stipulation in the treaty
right, or the
or the ordinance of 1787.
Yeah.
Otherwise, is what? Unlimited regarding
Mhm.
the territory, the federal. That would be the federal jurisdiction, territorial jurisdiction.
Right.
So this embodies what? United States territorial sovereignty that was transferred what by treaties.
Mhm.
And then what? Managed in the hands of Congress through the United States Constitution.
For
Right?
Section 3.
What else is? I mean, enforce what? Enforce this? Enforce the continuation? This is regarding our land. This is major. This ain't none. This is not small. Continue, brother.
But the power of Congress to regulate the other national property, unless it has acquired by cession of the state's exclusive jurisdiction, is not necessarily exclusive in all cases. If the national government own a fort, arsenal, hospital, or lighthouse establishment not so seated, the general jurisdiction of the state is not excluded in regard to the site, but subject to the rightful exercise of the powers of the national government, it remains in full force.
People versus Godfrey. People versus Godfrey. Uh, uh, um, People versus Godfrey. New York State Supreme Court case, 1819. An incident happened. A army soldier. A murder took place in the in the United States military base. An army soldier had as his prisoner an army soldier. On his way to the baronet, he kills the prisoner, an army soldier. He's charged. Now, the issue is that the federal government claimed to have jurisdiction over the case because the incident happened on a United States military base. So you would think that, yeah, Abdullah, it's a United States military base, Abdullah. Wouldn't the federal government, not necessarily, this is where it's coming from, this is what he explained, not necessarily, unless it was ceded, unless the territory was ceded. It could be United States military base, but it was never ceded. The land was never ceded. New York never ceded it to the federal. Where did New York get it from? Where did New York State get the land from? Great Britain, Article 1 of the 1783 Definitive Peace Treaty between Great Britain and the United States. This is what he's talking about. Not exclusive in all cases. So it was not exclusive in the People versus Godfrey case. Yes, it's United States military base, but the land was never ceded. New York never ceded the land. The continuation of European conquest, colonization, and subjugation of our land. Conscious Moors don't know this because they've been locked into this false paradigm as I was for 25 years, 35 Moors, that the Moors are the sovereign body of the Constitution. The Moors are I mean, just parroting now. It's just mere parroting. There's no studying. There's no studying about. Brother and sisters, I'm raising my hand. Please, to thyself be true. I was like those conscious Moors. The people that I'm talking about. I'm talking about myself. I was one of them. So I can talk trash because I'm talking about myself. I was one of them. So nobody can say I'm talking shit because I'm talking about myself. I was one of them for 25 years. A goddamn, excuse my language, a mere parrot. I was a parrot. I didn't see no evidence that 35 Moors was at the United States Constitution. I didn't see a shred of evidence that the Moors are we the people of the United States. I didn't see a shred of evidence that the Moors are the drafted Constitution. I didn't see a shred of evidence. If a conscious Moors lied to you, if a conscious Moors say they seen a shred, they are they are liar. They're liar. Don't change. I'm not changing the word. They're lying. They're lying. They're parroting like I did. To thy own self be true. If I'm going to move y'all people, if I'm going to move forward, I'm going to be ready to move forward with this. To thy own self be true. I was a parrot like these conscious Moors are parroting right now. I was just like them for 25 years. I cannot be ashamed. If I want to move the people forward, I cannot be ashamed to let people know I was like those conscious Moors that I'm talking about. I was just like them. I was parroting. I gotta grow. This has helped my growth. How many times I've said this, Amanda? Amanda must have heard me say this over 100 times.
Yes, many.
But I have to do that for my growth. Any questions? I'm challenging. I'm challenging those conscious Moors. I'm challenging. I'm challenging all those conscious Moors. This is how we're challenging it. We're challenging with this is how we're doing it. We're challenging scholastically. We're challenging them that way. This is how we're challenging them. And then you're going to have those that's going to, that's going to pick on so and so said, but 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 so and so said. What is that called? Blind faith. That's dangerous. That's blind faith. Because they admire. Don't admire me, my brothers and sisters. Please don't. Don't admire me. I'm no greater than y'all. Don't admire me though. I'm no greater than y'all. Y'all can come to learn this as I come to learn. We're breaking this down. Y'all gonna develop faster than me. Remember, I was stuck into the false paradigm for 25 years. How can you not develop faster than I? Look at how we're breaking it down. You're developing faster than I developed. Continue, Israel. I gotta, have to have that cathartic moment, man. No, it's important for me, man, because it's, being able to teach this to thousands of people for 25 years, man. and then to come to find that I'm still wrestling with that, my brothers and sisters. I'm still wrestling with that. So you gotta understand that.
All right. Territorial sovereignty ceded and relinquished to the United States with land boundary cession treaties with Great Britain, France, Spain, United States of Mexico, and Russia, and the subjugation and annexation of the Kingdom of Hawaii international law principles. Number one, acquisition of territory. Number two, loss of sovereignty. Number three, law of succession. Four, territorial sovereignty. Number five, acquisition of nationality through subjugation and cession. And number six, change of sovereignty and its effects upon the inhabitants. Article 4, Section 3 of the United States Constitution, 14th Amendment of 1868, the member states of the Union birthright certificates.
All right, yeah, next we're gonna just continue reading. Mhm.
Change of sovereignty and concessions. General principles. The principle of international law, as announced by Chief Justice Marshall in the famous Perchman case, and supported by a long list of American decisions, is that no confiscation of private property and land results from a mere change of sovereignty. Will this principle be sufficient and adequate to protect private property rights in concessions and contracts? In other words, since contracts no less than land may constitute valuable and irreplaceable private property, should any distinction be made in the application of the Perchman principle between land and contracts? Where the parties to the contracts are private persons or corporations, there seems to be no essential distinction between property in the form of land and property in the form of contracts. In either case, the change of sovereignty must of itself affect no forfeiture, where, for instance, territory passes out of the sovereignty of state X and under the sovereignty of state Y, just as state Y must not allow the change of sovereignty to affect the ownership of land held by a private individual, A, within the ceded territory. So state Y must not allow it to affect the ownership of contract rights held by A against some private obligor or debtor, B. Change of sovereignty of a people. Yeah, change of sovereignty of a people. All right. Laws, usages, and municipal regulations in force at the time of cession remain in force until changed by the new sovereignty. The new sovereignty may deal with the inhabitants and give them what law it pleases, unless restrained by the treaty of cession. But until alteration be made, the former law continues. By the recent treaty with Spain, sovereignty is ceded to the United States over Puerto Rico and the Philippine Islands with the following proviso. The civil and political status of the native inhabitants of the territories hereby ceded to the United States shall be determined by Congress. The ceding power imposes no conditions and reserves no rights defined and secured by the federal Constitution to the inhabitants of these new possessions. None of our territories have ever been organized under the Constitution, but are creatures exclusively of the legislative department of the government and subject to its supervision and control. And in a territory, all the functions of government are within the legislative jurisdiction of Congress. Consequently, it is for Congress to decide what the political status of residents of our new possessions shall be, whether they shall exercise the rights of suffrage or not, and that right, if granted, may be limited or extended at the will of Congress. The late treaty with Spain is distinguished from all others heretofore made by the United States in the acquisition of new territory. It is provided in the Treaty of 1803. That's supposed to be Louisiana. Yeah. So the late treaty with France is distinguished
Mhm.
from all others heretofore made by the United States in the acquisition of new territory. It is provided in the Treaty of 1803 for the cession of Louisiana that the inhabitants of the ceded territory shall be incorporated in the Union of the United States and admitted as soon as possible, according to the principles of the federal Constitution, to the enjoyment of all the rights, advantages, and immunities of the citizens of the United States. And in the meantime, they shall be maintained and protected in the free enjoyment of their liberty, property, and the religion which they profess.
And that embodies international law. So Article 4, Section 3 of the United States Constitution embodies the territorial sovereignty principle.
Mhm.
So you have international law principles embodied in that article.
Yep.
So once you see the elements, once you know the principle, and you see the elements that's in the Constitution. I continue read this here, so they can have
All right.
they can get some, they can see literature. I mean,
Yeah.
supportive literature.
All right. So status of inhabitants of territory acquired by discovery, purchase, cession, or conquest, according to the usage of the United States. From an early period in American history, two principal theories were entertained and insisted upon by their respective advocates in reference to the power to acquire territory. These theories were conflicted and were influenced by the opposing interpretations which the national and states' rights schools placed upon the powers of Congress under constitutional grants. The states' rights school at first denied the United States had power under the Constitution to acquire new territory. The national school insisted that the power existed and was necessarily inherent in the government as an attribute of sovereignty. Notwithstanding the doubt and denial of the extreme state rights school, Louisiana and Florida were acquired by purchase, Texas by annexation, and an extensive territory was acquired by treaty with Mexico. The annexation of the Hawaiian Islands was effected by joint resolution of Congress. The Northwestern Territory acquired previous to the adoption of the federal Constitution by cession from Virginia was regulated by an ordinance for the government of the territory of the United States northwest of the River Ohio, adopted by the old Congress, July 13, 1787. Territorial governments have from time to time been organized out of the other territories of the United States. The recent act of Congress organizing the territory of Hawaii prescribes specifically what classes of the inhabitants shall be deemed citizens of the United States. The character and extent of the power of Congress over the territories have been the subject of repeated and excited discussion in and out of Congress. The National School have insisted that under the Constitution, Congress have absolute and despotic power over the territories. That whatever they have the power to do, they have the right to do, if in their judgment it will conduce to the general welfare.
Once again, I continue. Yeah, I'm gonna let you get territorial sovereignty. Mhm.
Territorial sovereignty is the right of a state to govern its territory and control its borders without outside interference. It's a fundamental principle of international law that helps define the relationship between nations. How does territorial sovereignty work? It gives a state the power to rule over its land and people. It emphasizes the importance of political independence and territorial integrity. It helps states claim land and resolve conflicts over territory. It's a key factor in international relations and law. Article 4, Section 3 of the U.S. Constitution gives Congress the power to govern U.S. territories and property. This includes the power to create political divisions, set rules and regulations, and dispose of the territory. How does this apply to U.S. territories? Congress can create territorial governments within the U.S. Congress can incorporate territories into the U.S., granting them the same constitutional protections as U.S. residents. Congress can also regulate unincorporated territories, which are not on the path to statehood. Congress can allow U.S. territories to become independent nations, as was done with the Philippines. Key points about Article 4, Section 3 and territorial sovereignty. Plenary power. This clause gives Congress broad and complete power to manage territories, including establishing local governments, creating laws, and regulating property within those territories. Admission of new states. The section also outlines the process for admitting new states into the Union, requiring congressional approval and ensuring that new states are admitted on an equal footing with existing states. Historical context. The founding fathers included this provision to address the issue of newly acquired land from the Louisiana Purchase and to ensure consistent governance across different territories. Northwest Ordinance as precedent. The Northwest Ordinance is often cited as a key example of how Congress utilized Article 4, Section 3 to establish a territorial government with provisions for eventual statehood. Important aspects of territorial sovereignty under Article 4, Section 3. No inherent statehood. Territories are not considered states and do not have full representation in Congress until admitted by Congress. Congressional oversight. Congress has the power to create and modify territorial governments, including setting rules for elections and establishing local laws. Evolution of territorial governance. As a territory develops and gains population, Congress may gradually grant more self-governance through the creation of a territorial legislature. When a territory changes sovereignty, the nationality of the people living there also changes, meaning their citizenship shifts to the new governing state, often determined by the new state's laws regarding nationality acquisition, potentially impacting their rights and obligations depending on the specific circumstances of the change in power. This is particularly relevant in situations like territorial transfers, annexation, or independence movements. Key points about how changes of sovereignty affect nationality. Automatic change. In most cases, when a territory changes hands, the inhabitants automatically acquire the nationality of the new sovereign state. Legal framework. International law, including treaties on state secession, provides guidelines on how nationality should be handled during sovereignty changes, but states still have some discretion in implementing these rules. Options for individuals. Depending on the specific situation, individuals might be given options to retain their old nationality, acquire the new nationality, or opt for a different path depending on their personal circumstances. Potential issues. Changes in sovereignty can lead to complexities like statelessness, where individuals are left without a nationality due to the transition, or situations where individuals are forced to choose between multiple nationalities. Examples of situations where changes of sovereignty affect nationality. Colonial independence. When a colony gains independence, the inhabitants usually become citizens of the new nation. Territorial cession. If a country transfers territory to another state, the people living in that territory typically become citizens of the new state. Examples of situations where changes of sovereignty affect nationality. Colonial independence. When a colony gains independence, the inhabitants usually become citizens of the new nation. Territorial cession. If a country transfers territory to another state, the people living in that territory typically become citizens of the new state. Annexation. When a country forcibly takes over another territory, the inhabitants may be granted or denied the nationality of the annexing state. Why is territorial sovereignty important? It's essential for understanding how states interact. It's important for resolving conflicts over land. It's a fundamental part of international law. It's a key factor in determining how states acquire and retain land. Related concepts: territorial integrity, the importance of maintaining a state's territory; political independence, the importance of a state's freedom from outside interference; statehood, the legal concept of a state's right to exist and rule over a territory.
So here, related concepts.
Question: How was the United States? Question: How has the United States subjected the Moors / Black Moors / Blackamoors / Blacks to its jurisdiction? Answer: Born in the United States, subject to the jurisdiction thereof. Territorial sovereignty ceded and relinquished to the United States with land boundary cession treaties with Great Britain, France, Spain, United States of Mexico, and Russia, and the subjugation and annexation of the Kingdom of Hawaii. International law principles. Number 1, acquisition of territory. Number 2, loss of sovereignty. Number 3, law of succession. Number 4, territorial sovereignty. Number 5, acquisition of nationality through subjugation and cession. And number 6, change of sovereignty and its effects upon the inhabitants. Article 4, Section 3 of the United States Constitution, 14th Amendment of 1868, the member states of the Union birthright certificates. Of the Union and birthright certificates. Showing the current state and condition of our people. Application of international law. Territorial sovereignty. A nation's exclusive right to govern its territory and control its natural resources without external interference. A principle that underpins state independence and autonomy. A treaty is the vehicle in which territorial sovereignty is ceded, transferred, conveyed. A treaty is not an application of law. Land boundary cession treaties. Examples: Article 1 in the 1783 Definitive Peace Treaty between United States and Great Britain. Great Britain cedes British territorial sovereignty to the United States. Article 3 in the 1803 Louisiana Purchase Treaty between United States and France. France cedes French territorial sovereignty to the United States. Article 2 in the 1819 Adams-Onis Treaty between United States and Spain. Spain cedes Spanish territorial sovereignty to the United States. Article 8 in the 1848 Treaty of Guadalupe, Hidalgo, between United States and United States of Mexico. Mexico cedes Mexican territorial sovereignty to the United States. Article 1 in the 1867 Alaska Treaty of Cession between United States and Russia. Russia cedes Russian territorial sovereignty to the United States. Showing the current state and condition of our people. Application of international law. Land boundary cession treaties with Great Britain, France, Spain, and the United States of America. Acquisition of territorial sovereignty. Transfer of territorial sovereignty. Acquisition of nationality. Change of territorial sovereignty and the effects upon the inhabitants. 14th Amendment of 1868. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. States' birth certificates. How do the Moors slash Black Moors slash Blackamoors blacks or slash blacks properly challenge the United States claim of born in the United States and subject to the jurisdiction thereof? And this is the proper way of challenging it, the claim. Nationality, self-determination, self-government, post-millennium, recovery of lost sovereignty, reversion to sovereignty, Moorish treaties protections, and Moorish consular relations. So questions about the book that the brother Abdullah and I are working on. What do the authors hope to accomplish with the book? How would knowing that the United States Constitution continues European discovery, conquest, subjugation, and colonization of Moorish lands, and therefore the subjugation, benefit our people? How is this information useful? What is the projected release date of the book?
All right, we can go to the projected lease relates. I'll just the last one I'll answer. I think I said it. Spring of 2026. The other questions we'll answer later on. You know, we'll be ending soon. Is this the last slide?
Yep, last slide.
All right, good. All right, so it's 9:17. This will be uploaded tomorrow, and we'll put on the and on the Telegram page. I want to thank you, everyone. Let other people know about these classes. Share this video. I think this is more complete than the first class we did. All right, so definitely want to share this one. We did this on Monday, Moorish Monday, 2 days ago. All right, so until thank you, Amanda, for piloting.
You're welcome.
All right, so we see y'all 2 weeks on this platform, and on Moorish Monday we'll have Luisa Flores. She'll be 7 p.m. Eastern Standard Time, Moorish Mondays. This is a rescheduling. So I'll see y'all on Monday, Moorish Monday, 7 p.m. with Luisa Flores. All right, peace, everyone. Hit the
Peace.
end the recording.